A rainy afternoon to you guys. So today, we will be discussing the third chapter of the partnership law, which is dissolution and winding up. So this chapter composes of articles 1828 down to 1842. So we start. If you read Article 1828 and 1829, um, three terms are being defined: dissolution, winding up, and termination, which is summarized in our lesson, which you could find in our LMS class. Okay. As defined by Article 1828, dissolution is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on of the business. But partnership is not terminated but continues until the winding up of the partnership affairs is completed. It is explained further in the next article, okay, that which says na kapag ang partnership na-reach na niya yung point ng dissolution, it does not mean that the partnership's life is over. Okay? Hindi pa siya natatapos. It continues until the winding up of affairs is completed. And therefore, once dissolution happens and the partnership plans to wind up the affairs, okay, edi gawin nila. They wind up the partnership affairs. Tapusin nila yung mga kailangan nilang tapusin, ibenta nila yung mga assets, or distribute it to the partners. And once that is over, saka natin masasabi na tapos na yung buhay ng partnership. That partnership is already terminated. Pwede bang hindi mag-wind up ng affairs pagdating ng dissolution? Oo naman. Okay? The partnership business can still continue despite dissolution. Okay? Pero ang sinasabi lang ng Article 1829, in cases wherein pinaplano na ng mga partners na tapusin na talaga yung partnership, it does not mean na kapag na-dissolve na yung partnership, terminated na siya. Okay? So, kung ilalagay natin yan into a timeline, anong mauuna? Of course, dissolution. Okay? And then after dissolution, winding up. Pag natapos na yung winding up, saka siya mataterminate. Okay? Yan ang chronological order ng tatlong terms na yan. Dissolution muna, and then they wind up partnership affairs, and then lastly, pag tapos na lahat yan, terminated na siya. By the way, no, yung lesson natin for this afternoon will be divided into several parts. The first is yun nga, in the definition natin ng dissolution, which we already finished. Second part would be the causes of dissolution, and then the effects of dissolution. This is the largest part. Okay, this is the largest chunk of this chapter. And then finally, hiniwalay na lang namin ito, yung persons authorized to wind up, because this is such a short discussion lang naman. But yung itong persons authorized to wind up na ito, you can find this sa Article 18. Okay, ito 1836. Okay? Ito siya. Persons authorized to wind up is found here in Article 1836, pero hinuli na lang namin dito sa presentation natin ng summary. Okay, na makikita nyo sa LMS natin. So we move on to the second part. The causes of dissolution. So sabi nga natin, dissolution is the change in the relation of the partners. Pero what causes the change in the relation of the partners? Okay? Number one, pwedeng magkaroon ng dissolution na walang violation ng agreement between the partners. Okay? Una, by the termination of the definite term or the particular undertaking specified in the agreement. So that was discussed na doon sa pangalawang live natin. So, sabi nga natin before, pati na rin sa first na live natin na pag-usapan natin yan doon sa types of partnerships. So sabi nga natin, kapag ang partnership is with a fixed term or with a particular undertaking, once na dumaan na or lumipas na yung fixed term na yan, pati yung particular undertaking, automatic madidissolve yan. Pero the partners have an option to continue with their business, and if that happens, that partnership with a fixed term or particular undertaking is converted into a partnership at will. Okay? So, yun, letter A. Letter B, okay, ito naman, kapag ang partnership is a partnership at will, ibig sabihin by the express will of any partner, kung kailan niya gusto. Okay? Pero dapat good faith. Okay? So, ayan, when no definite term or particular undertaking is specified, ibig sabihin partnership with a fixed term. So, kapag partnership with a fixed term, dissolution can be caused by the express will of a partner. Sabi nung isa, ayoko na. Ayun. 'Di ba? Siguro nakaka-relate din kayo, no? So, if for example in your relationships, which maybe you could consider as a partnership, pero in legal sense hindi, of course. Okay? Pero parang ganon. Tapos sabi nung isa, ayaw na. Okay? Di wala tayong magagawa, hindi na maipagpapatuloy yan. Okay? The legal principle that applies here in letter B is delectus personae. So kung ayaw na ng isa, okay, sabi nga natin dun sa delectus personae, every person has a right to be partners with the people na gusto niyang maging partner. Kung ayaw niya yung tao, edi wala namang pumipilit sa kanya makipag-partner doon, 'di ba? So, if a partner reaches that point na ayaw na niyang ituloy yung partnership, okay? Edi yun, it will cause a dissolution. Okay, letter C. By the express will of all the partners who have not assigned their interest. Okay? So, pwedeng express will lang ng isang partner, pwede ring express will ng lahat ng partners. Okay? So, express will ng mga partners, well, ganito magiging required yung unanimous decision ng mga partners to terminate or to dissolve the partnership kapag pag ang partnership is a partnership with a fixed term or a particular undertaking. Yun ang difference ng B tsaka C. Pag letter B, pag partnership at will, kahit isa lang sa mga partners, okay, pwede nang i-cause yung dissolution. Pero for letter C, okay, kapag partnership with a fixed term or particular undertaking, kailangan lahat ng partners mag-agree. Okay? So, ayun. Yun yung difference lang dalawa. And letter C, pag may partner na na-expel. Okay? Pag may na-expel na partner, then, ayun, magkakaroon ng dissolution. Kasi, in all cases, no, except letter A, in cases B, C, and D, okay, there will be a change in the relations of the partners. May matatanggal na isang partner. In the case of letter B, yung partner na umayaw, mawawala siya dun sa partnership, mababawasan yung mga partners. So that's a change in the relation of the partners. C naman, express will of the partner. So wala ng partners kasi nga wala na yung partnership. Ganon din sa letter A. Pag na-terminate na ito, automatic, okay, wala ng partnership. Okay? And then letter D naman, pag may na-expel na partner, di nabawasan na naman din yung number of partners. So, ayun. So, all of this, merong change sa relations ng mga partners. Okay, number 2, in contravention of the agreement between the partners where the circumstances do not permit a dissolution under any other provision of this article by the express will of any partner at any time. Dito kasi sa number 1, this is without violation of the agreement between the partners. Sa number 2 kasi, merong nagkaroon ng contravention or violation of the agreement between the partners. Whatever agreement man yan, basta it is stated in the articles of partnership, okay? Or kahit implied agreement, basta merong contravention, basta merong violation, then, ayan, magpo-fall siya under number 2. Okay? And then, number 3, by any event which makes it unlawful for business to be carried on or for the business to carry it on for the partnership. Ano kayang magandang example dito? By operation of law, yung business ninyo biglang bawal na. Ano nga ba? Let's say na lang na you are selling let's say gumawa kayo ng partnership for to sell airplane tickets for example, tapos biglang nagkaroon ng batas na sabi bawal nang bumili ng airplane tickets from travel agencies or from any other merchant other than the airline itself. So parang direct selling na lang. Pwede na lang bumili ng airplane tickets from the airline itself. Pag through a third person, hindi pwede. Or through its agents, hindi na pwede. Okay, di yung partnership nyo, madi-dissolve yan. Kasi ano pang purpose ninyo, di ba? Yung main operations ng business ninyo, wala na. Okay, so pag ganon, ayun, madi-dissolve yung partnership pag ganon. Pwedeng ang maging unlawful is yung business, okay, na ipagpatuloy or isang member, okay, na mag-carry on or isang partner na magtuloy na maging partner. Ang example dyan is if you were like kunwari GPP, law firm, and then one of the partners naging judge sa RTC, sa Regional Trial Courts. If that happens, madi-dissolve yung partnership and then a new partnership will be created. Bakit? Kasi nga yung partner na yon na naging judge, hindi na siya pwedeng magpatuloy as a partner of that partnership. Bakit? Kasi under the law sabi, kapag judge ka na, you cannot engage in the practice of law. So, yung GPP ninyo is, 'di ba, is for the exercise of a common profession. So, if you are still in the partnership, if you are still in the GPP, ibig sabihin, you are in the exercise of your legal profession. You are still in the practice of law. So, hindi dapat. Kasi nga, judge ka na eh. So, to prevent conflicts of interest, okay, dapat umalis ka na doon sa partnership. So, kapag umalis ka na, that is another cause for dissolution. Ayun. And then, number 4, okay, loss of specific thing promised by a partner before its delivery. Pwede natin i-relate itong Article 1830 na yan, itong 1830, where's 1830? Okay, itong number 4 ng 1830, I think pwede siyang i-relate doon sa mga earlier articles. I think 1780 something 'yon. Hanapin natin. Okay. Etong 1786 kasi, every partner is a debtor of the partnership for whatever he may have promised to contribute thereto. So, ang pinag-usapan natin dito nung ito ang lesson natin, once a partner fails to contribute what he promised, nagiging debtor siya. Okay? And if in case of losses, okay, pwede lang naman siyang pwede naman niyang may pwede siyang ipalit. Like for example, a partner promised to deliver a delivery truck, for example. Kapag nasira yung delivery truck na yon, as long as makapag-produce siya ng isa pang delivery truck tapos i-contribute niya, okay lang yun. Kaya lang, pagdating natin dito sa 1830, okay, ang gustong sabihin nitong 1830 na ito, okay, kapag ang i-contribute ay specific thing, okay, bakit? We have this legal principle which we call, i-type ulit natin. Okay, medyo matututo tayo ng mga Latin legal maxims dito, no? Okay, meron kasi tayong legal principle which we call, wait lang, set lang natin yung font. Okay, eto. Genus nunquam perit. Ibig sabihin, genus never perishes. Yun ang ibig sabihin nito. Okay, italicize natin kasi Latin siya. Okay, ang ibig sabihin is genus never perishes. Okay? So, napag-usapan natin before yung delectus personae, okay, and then yung res perit domino, which is just a review of your review lang naman siya nung obligations ninyo kasi napag-usapan na yan sa oblicon ninyo. Okay? Yung res perit domino, the thing perishes with the owner. Ito naman, genus nunquam perit. Okay? Genus never perishes. Anong ibig sabihin nito? Okay, if the thing is generic, ibig sabihin hindi mauubos 'yan. If for example, ang obligation mo is to give a pair of shoes sa isang tao doon sa creditor, edi pag nawala yung sapatos na yon na ihahanda mo na sanang ibigay doon sa creditor mo, you can always produce another shoe. Pwede kang bumili ulit and then yun ang ibigay mo. Okay? Pero kapag specific kasi, nothing replaces specific things. Okay? I hope naalala pa ninyo yung generic tsaka specific ninyo. Okay? Pag sinabing generic, let's say 1,000 pesos, is that generic or specific? Okay, that's generic. Kasi pag nawala yung 1,000, pwede ka naman kumuha ng isa pang 1,000 and then yun ang ibigay mo. Okay? Pero kapag specific, for example, cellphone number na may IMEI number na ganito ganyan, o di wala nang ibang cellphone na ganon ang IMEI number niya, 'di ba? So wala na. So dito sa Article 1830, specific thing eh. So wala nang papalit dito sa specific thing na to. Once this gets lost, edi wala na. Hindi mo na siya pwedeng mapalitan. So if for example, a car na may not plate number, dapat chassis number. Okay, kasi yun yung nagbibigay ng identity doon sa car. Okay? Kasi pag plate number, napapalitan naman ng plate number, pero ang chassis number, hindi. So, a car with chassis number, ganito, ganyan, yun yung prinamis mo, and then nawala, o di, wala na. Okay, hindi na pwedeng mapalitan. So, if this happens, okay, ang prinamis mo ay specific thing, okay, nawala siya before delivery, nasa'yo pa. Okay? Ide-deliver mo pa lang, ibibigay mo pa lang dun sa partnership, i-contribute mo pa lang. Pero just before that happens, nawala siya. Okay? Or nasira or yun. Kapag ganun ang nangyari, okay? Pag ganun ang nangyari, edi madi-dissolve ang partnership kasi nga sabi dito sa Article 80 number 4. Okay? That is if nawala siya before delivery. yun naman ang sabi dito sa number 4. Okay? Before the delivery. Okay? Pero kapag after delivery naman, hindi siya madi-dissolve. Why? Because the partner was able to contribute. Okay, naibigay niya. Na-transfer niya yung ownership doon sa partnership. Okay? Na-transfer ni partner kay partnership ang ownership. Okay? Ayun, hindi siya mawawala. Okay? Kasi ang kinaibahan kapag before, parang wala ka na ring contribution. Okay? Kasi yung kinontribute mo nawala and you cannot substitute it. Hindi mo na pwedeng wala ka nang maihahanap na kaparehas to satisfy your obligation. Ganito kasi, um, if you remember yung modes of extinguishment ng obligations ninyo, one of them is loss of the thing, 'di ba? So um, kapag ang nawala ay specific thing, okay? Extinguish na ang obligation. Tapos i-determine mo na lang kung sino ang may kasalanan. Okay, was it lost because of the fault of the debtor, or was it because of other persons, or was it because of force majeure? But anyway, a review lang 'yon. Pero ganun ang effect niya. Kasi since you failed to promise, sabi nga ng Article 1786 kanina, you are converted, or parang ang treatment sa'yo para kang debtor ng partnership. So, if debtor ka ng partnership at ang partnership ang creditor, tapos yung specific thing nawala before delivery, edi papasok yun doon sa loss of the thing, which is a mode of extinguishment. So, yung obligation ni partner, which is the debtor, na ibigay or i-deliver yung specific thing na yun kay partnership, which is the creditor, is already extinguished. Okay? Wala na yun. So, kaya ganon. Kaya nadi-dissolve yung partnership because of that. Okay? So, ayun, naitali na naman natin sa isang, I hope talaga hindi nyo nakakalimutan yung mga concepts ng obligations and contracts niyo, because they are really very important sa pag-aaral ninyo ng mga next laws ninyo. Okay, ito, partnership and corporation, and of course, next SEM, yung sales natin. Kasi yung oblicon na yan is the very foundation of your business laws. Anyway, ayun na. I hope that's clear. Before delivery, partnership is dissolved. After delivery, it's not dissolved. Okay, ganun lang kasimple. Number 5, by the death of any partner. If a partner dies, ibig sabihin, ayun, there will be a change in the relations of the partners, because yun nga, the dead partner cannot carry on. Okay, hindi na niya maipagpapatuloy yung partnership. So, wala na siya. Okay, so since the death will cause kabawasan doon sa number ng mga partners, that is change. Pag sinabi natin change, increase or decrease, di ba? So, ayun. Number 6, by the insolvency of any partner. Okay? Ito, pag insolvent ang isang partner, ayan, madidissolve din ang partnership. Why? Okay? Kasi parang mahihirapan na itong partner na ito, itong insolvent partner na ito to contribute, okay, in case na magkaroon ng losses thereafter. Okay? So, ayun. Kapag in the future kulang na yung assets, parang nagsasuffer na ng losses yung partnership, and then ang daming creditors na nagke-claim doon sa mga natitirang assets ng partnership. If that is not enough, yung assets para mabayaran yung mga liabilities ng partnership, this partner, itong insolvent partner na to, might not be able to contribute. Okay, kaya yun, magkakaroon ng dissolution kapag may insolvency ng kahit sinong partner. Next, by the civil interdiction of any partner. Ito kasi, pag sinabi mong civil interdiction, kumbaga sa mata ng batas, patay ka na. Okay? Although, naturally, buhay ka pa, pero sa mata ng batas, parang patay ka na. Because you are prevented from managing your properties. Okay? And that includes the disposition of your properties. So, kapag yun nga, dumating na naman yung time na magkakaroon ng claims yung mga creditors ng partnership doon sa separate properties ng partner, kasi nga, 'di ba, sabi natin, ang creditors pwede lang mag-claim doon sa assets ng partnership. If that is not enough, saka siya pwedeng humabol doon sa separate properties ng mga partners. But if a partner, okay, na merong civil interdiction, parang pinatawan ng civil interdiction, yun nga, hindi siya pwedeng mag-dispose ng kanyang property. So, paano maita-transfer yung properties niya doon sa partnership creditors? So, ayun. So, pag may civil interdiction, dissolution is cause. Another reason kung bakit cause itong civil interdiction is because ang civil interdiction is incapacity. Eh, di ba ang partnership ay isang contract. So, if ang partnership ay isang contract, ibig sabihin dapat yung mga contracting parties meron silang capacity to enter into such contracts. Itong civil interdiction, this is incapacity. So ayun, hindi na pwede. Okay? So mag-cause siya ng dissolution ng partnership nyo. Okay? And lastly, pwedeng by decree of court under Article 1831, which is the following article. Okay? Ito kasi, itong 1830, this is, kumbaga parang extrajudicial. This is outside the court. Pag judicial naman, ito, 1831. Okay? A partner, ayan, on application by or for a partner, the court shall decree a dissolution. Pwedeng mag-decide ang korte ng dissolution upon application by or for a partner. So, itong Article 1831, this is divided into two. Okay? Itong mga cases na ito, these are cases wherein pwedeng mag-apply for dissolution ng isang partner. Okay? Or para sa isang partner, maybe kanyang legal representative. Okay? Itong last naman na dalawa, okay, on the application of the purchaser. Okay? Hindi siya partner pero may balak siyang bumili ng interest ng isang partner. Okay? So, ayan siya nahati. Number 1, a partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. Again, this is an incapacity. Na learn nyo naman sa contracts, di ba? Na incapacitated ang mga ito. Okay? Pag declared insane or of unsound mind. Okay? Pag sinabing insane, except lucid intervals. Ang lucid intervals, yun yung mga pagkakataon na nasa matinong pag-iisip siya. Mostly, wala siya sa katinuan, pero there are times wherein meron siyang konting katinuan, meron siyang konting sanity, and that is what we call lucid intervals. Okay? Number 2, a partner becomes in any other way incapable. O yun nga, ang ano naman nito, ang bottom line naman nito is yun nga, incapacity. Kaya lang, may nag-a-allege, may nag-a-apply, may nag-a-accuse, may nagsasabi. Okay? Ayun. And then, number 3, okay, guilty of such conduct as tends to affect prejudicially the carrying on of the business. Okay, parang ano yan, misconduct, okay, or parang ano na siya parang nakakasagabal na siya, okay? Nakaka-hurt. It really hurts na doon sa partnership, okay? Or doon sa business. So, ayun. Kapag guilty siya sa ganong conduct na nakakasira, detrimental to the carrying on of the business, edi ayun. And then, next, take note ha, hindi ito automatic. Okay? Hindi ito automatic. By application ito. Etong mga nauna, automatic tong mga ito. Okay? Sa Article 1830. Sa 1831, although this happens, kahit naman existing yan, kung walang nag-apply, walang nagpunta sa korte, okay, di wala. Okay? And then, number 4, ganun din. Nakakasagabal na siya doon sa business. Okay? Number 5, the business of the partnership can only be carried on at a loss. So, for example, one partner feel niya loss na, okay, let's say that it is a partnership for a particular undertaking or at a fixed term, eh, di ba nga, sabi natin, hindi siya pwedeng mag-dissolve ng partnership on his own. Kailangan unanimous yung lahat ng partners. Pero pwede niyang applyan yun. Okay? Feel niya, parang lagi na silang lugi. So, ayaw na niya. Pero, kung sarili lang niya, hindi madi-dissolve yung partnership kasi nga, hindi pa dumarating yung fixed term, for example. So, pwede niyang i-apply yan. Okay? Sabi niya sa korte, ipapa-dissolve ko na tong partnership. Okay? Ayoko na. Ayun. Will the court grant that sa tingin ninyo? Pwede. Okay? Because itong partnership, sabi nga natin, 'di ba, ordinary business partnerships are ang primary purpose niyan is to generate profits. Okay, pinag-uusapan natin 'yan from the very beginning, no? And kapag ayun na nga, parang lagi na lang loss. Okay, parang never na kayo nagkakaroon ng gains. Puro loss. Eh di, wala na, de-defeat na yung purpose ng partnership ninyo, which is to generate profit. So, the court can grant your petition na i-dissolve na yung partnership. Okay? And other circumstances, parang catch basin lang ito. Okay? Basta i-approve ng court, okay, di madi-dissolve siya. Okay? By order of the court. And ito naman, pwede rin naman, okay, on the application of the purchaser of a partner's interest, okay? After termination of the specified term or particular undertaking. So, pwedeng yung purchaser of a partner's interest, okay, hilingin niya sa korte na ipa-dissolve yung partnership, okay? Pero at any time naman kapag partnership at will, okay? So ulitin ko pwedeng applyan or pwedeng hilingin ng isang purchaser of a partner's interest sa korte na i-dissolve only after the termination, okay, of the specified term or particular undertaking. Pero kapag partnership at will, at any time. 1832, 33, 34. Okay, etong tatlong articles na ito talks about now etong effects of dissolution. Particularly ito, yung letter A, authority of partner to bind the partnership. Okay? So, sabi nga natin, merong mutual agency between the partners and the partnership such that if the partners act, they can bind the partnership. Okay? Pero, does that carry on even after dissolution? Okay? The general rule is, according to Article 1832, dissolution terminates all authority. Pero syempre may exception. Okay? The general rule is, ayan nga, terminated lahat. Okay? Ayan, authority of partners to bind partnership is terminated. Ayan siya. Okay, this is the general rule. But, exception, ayan, kapag necessary to wind up the partnership affairs or to complete unfinished business. Okay? Yan lang ang mga exceptions. Okay, syempre, kapag, for example, in winding up the affairs, kailangan mong magbenta ng mga properties so that you could realize magkaroon ka ng cash for distribution to the partners. Kasi mahirap naman kung kunwari yung furniture, yung handle doon sa isang partner, yung uupuan doon sa isang partner, yung legs doon sa isang partner. Mahirap naman yun. Kaya minsan, in winding up partnership affairs, binebenta muna or nire-realize muna yung mga non-cash assets. Okay, I hope this parang familiar, di ba? Kasi hindi ba yan yung ginagawa natin noong FAR? Okay? Mamaya, madidiscuss ulit natin yan. Maire-relate ulit natin yan doon sa ginagawa na ninyo noong ang lesson natin is partnership. Noong FAR nyo. Okay? So, ayun. So, syempre, kapag magre-realize ka ng non-cash assets, if you're going to sell some properties, whether movable or immovable, will the partnership be bound? Kunwari ako, I am a partner in a partnership that was just dissolved. And we are now in the process of winding up. Okay, and in winding up, we were able to sell. Okay, kapag nagbenta ba ako ng isang non-cash asset namin ng partnership, does that bind all the other partners and and yung partnership? Oo. Okay, because that is necessary to wind up partnership affairs. Okay? So, 'yun. Pero meron tayong qualifications. Pag with respect to partners, okay, that is provided for by Article 1833, and with respect to persons not partners, ayan, as provided by Article 1834. So, kapag with respect to partners, ayan, ito okay, kapag ang dissolution is not by the act, insolvency, or death of a partner, ayun, terminated na rin, okay, ang authority ng partners to bind the partnership. Pero if the cause of the dissolution is due to the act, to the death or insolvency of a partner, okay, na may hiwalay pa yan sa dalawa. Okay, kapag act of the partner, acting partner must have knowledge of such dissolution. Okay. And then ito, kapag death or insolvency, dapat meron siyang knowledge or notice. Okay, mere notice is already sufficient para dito sa death or insolvency. Now, anong difference ng knowledge tsaka notice? Okay? Parang mas malawak, ganito na lang, mas malawak ang knowledge kaysa notice. Kumbaga pag notice, in both cases, aware ka, okay, about the act or the death or the insolvency in both cases. Kaya lang, knowledge is more encompassing kasi mas may alam ka pa doon sa talagang nangyari. Marami ka pang ibang facts na alam, okay, regarding the event that happened. Okay? Yung notice, okay, nabalitaan mo lang. Okay? Pero kapag knowledge, mas may hindi mo lang nabalitaan, meron ka pang alam na iba pang details. Okay? So basta tandaan na lang natin, knowledge is more encompassing than notice. So, ang sinasabi nitong Article 1834, 33, okay, is that general rule nga kasi 'di ba is that authority of partners to bind partnership is terminated. Okay? So the same rule applies kapag hindi due to the act, death or insolvency of the partner. Pero if it is due to the act, death or insolvency, hindi automatic na terminated. Okay? Hindi siya automatically terminated yung kanyang mutual agency, yung kanyang authority to bind the partnership. Okay? Mata-terminate lang yan, okay, if merong knowledge, okay, both sa act, sa death, and sa insolvency. Pero kapag death or insolvency, kahit notice lang, okay na, terminated na yung authority of the partners to bind the partnership. Okay? Next. With respect to persons not partners. Ito kasi meron kasing um, may power ang isang partner, okay, to bind, okay, the other partners by his acts. Okay? Meron siyang ginawa and then damay yung lahat ng iba pang partners. Okay? Yun ang ibig sabihin natin when we say bind the partnership. Okay? Not only the partnership but also the partner. So, ito yung rules, okay, with respect to partners. Ibig sabihin, kapag nag-enter pa into a contract after dissolution, okay, dito natin makikita kung yung iba bang partners bound din doon sa ginawa nung isang partner na yon. Okay? So, ito siya. And then, with respect to persons not partners, ibig sabihin mga third persons. Okay? So, dito sa Article 1834, there is a protection given to innocent third persons. Kasi nga, yun ang focus naman dito sa number 2. Okay? With respect to third persons. Okay? Third persons yan, yung persons not partners. Okay? So, the partner continues to bind the partnership even after dissolution in the following cases. Okay? Number 1, transactions in connection to winding up partnership affairs or completing unfinished transactions. Yun nga kasi yung general rule, di ba? So if it is necessary to in the winding up of the affairs of a partnership, the mutual agency is still there. Okay, the partner still continues to bind the partnership kahit na nagkaroon na ng dissolution. Okay? Ayun naman yung general, ayun naman yung exceptions Okay? So, susunod, number 2, okay? What if, okay, hindi siya pasok dito sa number 1. What if hindi siya sa winding up or sa unfinished transactions? So, tignan natin yung Article 1834. Ayan. By any transaction. Kahit na hindi na siya pasok dito sa number 1, kahit hindi na siya appropriate doon sa winding up or doon sa pag-finish ng mga unfinished business. Okay? As long as the third person had extended credit to the partnership prior to dissolution and wala siyang knowledge or notice of the dissolution. Okay? This is to protect nga, like I said, innocent third persons. Kasi, for example, nagkaroon na ng dissolution. Okay, may nag-withdraw na partner, for example. The other partners entered into into a sale transaction, for example, with a supplier. Okay, yung supplier is a third person. Okay? And then, what if, ayun na nga, nag-enter yung supplier and the other partners into a transaction. Okay? And itong supplier na to, wala siyang knowledge or notice ng dissolution. Okay? Will the partnership or I mean bound ba yung third person doon sa contract na yun? Okay? Pwede ba niyang sabihin na hindi, valid yung contract of sale namin? Okay? Pwede, because the other party had extended credit to the partnership prior to dissolution. Ay, hindi, prior pala. Okay, sorry. Prior to dissolution Ay, hindi. Okay, sorry. Tama lang yun. Pero basta nag-extend na siya ng credit prior to dissolution. Okay? And had no knowledge or notice of the dissolution. So, yun. Tama pala yung example ko. Okay? And then, dito sa second na case, although hindi siya nag-extend ng credit, okay, pero kilala niya yung partnership prior to dissolution and although wala siyang knowledge or notice of dissolution, the fact of dissolution had not been advertised. Okay, if there is no advertisement in a newspaper of general circulation in the place, Okay? Ibig sabihin, third persons will still be bound by the acts of the partners. Okay? Pero kapag merong advertisement in a newspaper of general circulation in the place, okay, na-announce siya sa dyaryo, ibig sabihin, parang tantamount na yan sa general knowledge. Parang, di ba, ang sinasabi naman natin kapag ang isang tao may general knowledge, parang meron siyang knowledge ng isang average newspaper reader. Basta nagbabasa siya ng newspaper daily, that is already sufficient to say na ang taong yun, meron siyang general knowledge. Now, kapag, yun nga, if something has been advertised in a newspaper of general circulation, ang ibig sabihin lang nun, that is now public knowledge. So, if the partnership's dissolution is announced or advertised in a newspaper of general circulation in the place, ibig sabihin, parang ina-assume na, okay, na alam na ng lahat yun. Okay? So, this third person, ibig sabihin, kahit hindi niya nabasa, pine-presume ng batas na alam na niya because it is already advertised in a newspaper of general circulation. Sabi niya dito kasi, okay, a partnership can bind the partnership in the following cases. Pag walang advertisement. Pero kapag may advertisement, terminated na yung authority ng partner to bind the partnership. Okay? So itong mga cases na ito, okay, these are cases wherein the partner can still bind the partnership. Okay? Ayun. Let's review. Okay? By any act appropriate for winding up or completing unfinished transactions. Okay? Nasabi naman na natin 'yan. Kasi nga this is very important, okay? Para matapos na yung para ma-settle na yung mga accounts, pagbabayad na sa mga creditors, okay, and other things, okay? So, ayan, meron pa ring mutual agency diyan. The partners or a partner can still bind the partnership in this case. Pero pwede rin naman na ibang transactions not necessary for the winding up of the partnership affairs as long as walang knowledge. Okay? Kasi kapag alam ng third persons yung dissolution, ba't pa siya mag-enter into that transactions, nabuwag naman na, na-dissolve naman na yung partnership. Okay, so this is, yun nga, as I have said a while ago, this is in protection, okay, sa innocent third persons. Okay? So, and another case is walang advertisement in a newspaper of general circulation. Okay? Ayan siya. Ayan. This is the summary. Okay? The next paragraphs, okay? Ito, yung third paragraph. This one, okay? These are cases wherein hindi na bound ang third persons doon sa act ng partnership. Kasi itong kanina, this first paragraph, hanggang dito lang. This first paragraph, these are the cases wherein the partner can still bind third persons by his act. Ito naman, hindi na. Hindi na sila bound dito. Okay? So, if the partnership is dissolved dahil unlawful na magpatuloy ng business, okay, unless appropriate for winding up ng partnership affairs. Okay? So, if the cause is yun nga dahil unlawful na ipagpatuloy yung business, edi ayun na. Hindi na bound yung third persons doon sa acts ng partner na yon. Okay? Kapag ang partner naging insolvent, ganun din, nawawala na yung mutual agency, wala nang authority yung partner na i-bind yung mga third persons by his act. And kapag ang partner walang authority to wind up partnership affairs, kasi nga ang inaalaw lang ng batas, kasi sabi nga natin, general rule, terminated na. pero inaalaw lang ng batas na i-bind, na magkaroon ng authority to bind ang mga partners para lang i-facilitate, okay, yung pagtatapos ng partnership life, and that is yung winding up of the partnership affairs. So, kapag wala ka namang authority to wind up partnership affairs, ibig sabihin, any act that you do, you cannot bind third persons, okay? Hindi mo parang pwedeng i-allege ng third person na yun, ay, yung nakatransaction ko pala, wala palang authority to wind up partnership affairs. O di, wala palang effect, wala palang visa yung transaction namin. Okay? Except lang if, eto. Okay? Kasi nga, the ultimate reason for this is the protection of innocent third persons. So, if ang third person alam naman niya at pinagpatuloy pa rin yung transaction, edi okay, bahala ka. Alam mo yung pinapasok mo, okay? Kasi there are cases wherein hindi niya alam. Okay? So, ayun. Okay, I hope that's clear. So, yun na. 1832 hanggang 1834 discusses etong qualifications doon sa or itong authority of the partner to bind the partnership, which is the first effect of dissolution. Okay? The first effect of dissolution is that it terminates the authority of the partners to bind the partnership, and with respect to himself, I mean with respect to his fellow partners and with respect to third persons. Okay? Ayun. And then second effect of dissolution, okay, may discharge ba ng liability? Okay? First question kasi is, dahil na-dissolve na ang partnership, dahil wala ng partnership, although operations niya tumatakbo pa rin kasi nagwa-wind up pa rin, okay? Nawawala ba yung mutual agency? The answer generally is yes. Okay, terminated. Exception, ito. Okay, and then there are more qualifications here as discussed. Now, pangalawa, discharge of liability. Since the partnership is a separate, distinct personality at siya naman ang may utang sa mga third persons, hindi naman kaming mga partners, okay, does that mean that upon dissolution of the partnership, we are discharged, kaming mga partners discharged na sa liability? Answer, no. Okay, generally. Okay? Dissolution does not discharge existing liability of the partner except if agreed between the partner and himself, okay, the person or partnership continuing the business, and by partnership creditors. Okay? Ayun. So, this is explained in Article 1835. Okay? Ayan. This is the general rule. The dissolution of the partnership does not of itself discharge the existing liability of any partner. Okay? A partner is discharged from any existing liability upon dissolution of the partnership by an agreement to that effect between himself, the partnership creditor, and the person or partnership continuing the business. Okay? Madi-discharge lang siya sa liability. Okay? A partner can only be discharged from existing liabilities if there is an agreement. Okay? Kailangan mag-agree yung partner na yon na i-discharge natin, and then yung creditors and the person or the partnership continuing the business. Kasi nga, sabi natin, in cases of dissolution, pwede bang magpatuloy pa rin yung business? Yes, yun nga lang, hindi ka nakasama. Now, that person na natanggal doon sa partnership, either by expulsion, by withdrawal, or by retirement, whatever, okay, tinatanong kung discharge na ba siya sa liability. Ayun. So, generally, hindi, except if agreed between the partner na pinag-uusapan, I mean, the partner na alis dun sa partnership, okay, yung mga creditors ng partnership, or the persons or the partnership continuing the business. Kasi in effect, this is a novation, di ba? another mode of extinguishment ng obligations. So, if there is a change in the debtors and creditors, yung mga tao, okay, that's novation. Okay? So, dito, instead na, for example, A, B, and C, sila ang partners, aalis na si A, si B and C na lang ang magpapatuloy ng business and then may creditors. 'Di ba? Now, magkakaroon ng novation because nawala na yung partnership eh. Okay? Yung partnership na may separate personality, nawala. And then, another person, I mean, another partnership with another separate juridical personality takes its place. O di, novation yun. Nagkaroon ng change doon sa debtors and creditors. So, kailangan magkaroon ng agreement, okay, between the creditor and the debtor. Okay? So, madi-discharge lang siya if there is an agreement to that effect. Okay? What about a deceased partner? Okay? Discharged ba siya sa liability? Okay? What if death yung cause ng dissolution? Yung namatay ba na yon is liable pa rin sa mga, or I mean, na-discharge ba yung partner na yon from his liabilities? Answer is yes. Na-discharge siya. But, okay, yung estate niya ang liable. Okay? See the difference, no? Yung tao mismo, wala na siyang capability para magbayad eh. Patay na eh. Okay? And therefore, discharge na siya sa kanyang liabilities. But, yung kanyang estate, yung kanyang naiwan na ari-arian na magkakaroon ng kanyang sariling administrator or executor, okay, yun ang magiging liable. Okay, you will learn more about estates pagdating ninyo sa estate tax next semester sa tax nyo. Okay? Taxation 1026 ata yun. Okay? Kasi ang pag-uusapan ninyo sa tax next semester, ngayon kasi 'di ba you're talking about income tax, no? And then pagdating nyo ng second sem, you will talk about a different kind of tax, which is yung business taxes and transfer taxes, and estate tax. That is a transfer tax kasi you're transferring the properties of a deceased person to another person. Ganon din yung effect dito sa partnership. If namatay ang isang partner, may iwan siyang estate. Now, yung estate niya will be subjected to estate tax. Okay? And before mako-compute yung estate tax, meron kasing pwedeng magkaroon ng mga claims doon sa estate na yon. So, there might be a partnership creditor or separate creditors na humahabol doon sa mga properties niya in satisfaction of their debts. So, pwede nilang habulin yon. Yun nga lang, hindi na yung namatay na tao ang liable doon, but the estate. Okay? So, the individual properties which composes yung estate, okay? Yung estate kasi binubuo yan ng mga ari-arian ng mga, binubuo yan ng ari-arian ng namatay na tao. Okay? Now, yun na ang magiging liable. The estate now is the one being liable, okay, to all the obligations of the partnership na na-incur habang partner siya. Kasi nga, at the point of his death, dissolved na yung partner eh. Ibig sabihin, yung liabilities only up to that point, yun lang ang liability nung estate niya. Okay, liabilities incurred by the new partnership after his death, hindi na, labas na siya doon. Okay, so that's Article 1835. Ayan, Discharge of Liability. Now, like I mentioned a while ago, itong Article 1836, ito siya. Okay, persons authorized to wind up. Okay, ang pwedeng mag-authorize ng winding up, okay, ng partnership affairs is partners designated by the agreement. Okay, pwedeng nakalagay yan sa articles of partnership na in case the partnership is leaning towards termination, the following partners are designated, ganyan. Okay, or the following partners are authorized to wind up. Okay, pwedeng na-designate yun. Okay, what if walang agreement? Okay, all partners who have not wrongfully dissolved the partnership. Okay, whether by fraud or whether by contravention of the agreement. Okay, pero kung wala namang ganon, edi ayun, all of them, all the partners. Pero if there are or if the partnership is dissolved by contravention of the agreement or by fraud or by misrepresentation, okay, edi yung mga partners na walang kasalanan. Okay, yung mga partners na ayan, ito, who have not wrongfully dissolved the partnership. Okay? And pwedeng legal representative of the last surviving partner. Okay? Ayan siya. Ito yun. Article 1836 yun. 37. Okay, Article 1837. Ito na yung application of the partnership property on dissolution. Ito. Okay? So, ito yung ginagawa natin pag nabasa niyo itong Article 1837, magiging familiar sa inyo to because you've been doing this already noong FAR ninyo pag nagsosolve kayo ng mga partnership na problems. Okay? So, there is a right, okay, by the partner, kaya lang dinivide niya sa dalawa. Okay? In cases wherein voluntary yung dissolution, ito ang mag-a-apply kasi walang contravention of agreement. Okay? What if merong contravention of agreement? Okay? Kasi hinihiwalay yan eh. Hinihiwalay yan because iba ang rights ng nag-cause ng wrongful dissolution, iba ang rights nung walang kasalanan. Okay? Siyempre, mas maraming rights yung mga walang kasalanan, those who did not cause the wrongful dissolution. Okay, now, dito muna tayo. What if there is no contravention of agreement? Okay? If there is no violation of the partnership agreement, all the partners can apply their partnership property to discharge the liabilities of the partnership. Okay? They can apply partnership property to discharge liabilities of the partnership. And then, if may matira, okay, yun na ang mare-receive nila. Okay? Siyempre, if you remember doon sa mapa-lump sum liquidation man yan or installment liquidation, di ba, nililista natin lahat ng accounts. Cash, non-cash assets, loans, okay? And then, yung liabilities na, pwedeng may loans ulit, and then, yung liabilities to outside creditors, and then, yung capital na, A capital, B capital, C capital. Di ba ganun yung una doon sa sa dissolution natin kapag gumagawa tayo ng statement of dissolution natin. So, anong inuuna natin? 'Di ba? We first satisfy, titignan natin yung cash kung enough ba siya to pay the liabilities. If not, we have to realize yung non-cash assets. 'Di ba ganun yung ginagawa natin sa FAR? So, eto siya. Okay? Partnership properties, okay, whether cash or non-cash, pwede siyang partnership assets can be applied to discharge the liabilities of the partnership. If may matira, yun na, i-distribute na yan sa mga partners. Okay? Pero, kasi, di ba, sa mga problems ninyo sa FAR, wala namang sinasabing may contravention of agreement. Di naman sinasabi yan sa problem, di ba? Okay, pero ito, this is a deeper appreciation of the situation, no? What if merong contravention of the agreement? Do they enjoy the same rights? Siyempre, yung mga walang kasalanan, they possess the same rights. Kasi dito, voluntary ito eh. Wala namang may kasalanan dyan. Okay? Pero dito, if there is a violation of agreement or pag merong fraud, ganyan, okay, those who are innocent can apply the partnership property, pwede magkaroon ng surplus, and they can also claim for damages kasi yung nag-cause ng wrongful dissolution, ayan, less damages caused by his wrongful dissolution. Yan ngayon ang mapupunta or mare-receive ng mga partners na inosente. Okay? They also have the right to continue the business in the same name. Okay? And to possess the partnership property if the business is continued. Kasi sabi nga natin, if the business is continued, that is a prima facie evidence na nagpapatuloy pa rin yung business, and therefore, if, for example, it is a partnership at a fixed term or for a particular undertaking, yun nga, di tuloy pa rin yung business. Okay, it is converted now into a partnership at will. So, if that happens, syempre, the partnership still exists, the operations still, nagpapatuloy pa rin yung operations niya, and therefore, the partnership property remains to be co-possessed by all the remaining partners. Okay? So, ayun. So, yung mga inosente, they have the right to possess the partnership property. Kasi nga, in any partnership naman, all of the partners are possessors or co-owners of the partnership property. Okay? Susunod, what if ikaw yung nag-cause ng wrongful dissolution? If the business is not continued, apply partnership property, okay, and then, pwede siyang makareceive pa rin kung may matitira pa. Kasi, mababawasan siya ng damages. Okay, parehas lang din doon sa mga inosente except that yung mga inosente may dagdag silang cash because of the indemnity. Okay? Pero yung may sala naman, okay, mababawasan kasi nga yung kanyang payment, okay? Yung kanyang compensation for the damages caused by the wrongful dissolution. Pero if continued by the others naman, okay, have the value of his interest at the time of dissolution ascertained. Kailangan computein kung magkano ang value ng interest niya at the time of dissolution, and then kailangan siyang bayaran. Okay? And then after that, i-release na siya from existing or future partnership liabilities. Ito kasi doon sa una, hindi na magkakaroon yan ng additional na liabilities because nga tapos na yung partnership. Okay? Ito tinuloy eh. So there is still the possibility that the partnership may still contract additional liabilities. Labas na siya doon. Okay? Labas na itong partner who wrongly caused the dissolution. Okay? Pero kapag hindi naman hindi na itinuloy, ibig sabihin magli-liquidate na sila, ayun na, magkakaroon na ng distribution to all the partners ng kanilang mga shares. Ayun, kung inosente ka, madadagdagan ng pera mo. Kapag hindi, mababawasan kasi nga there will be payments. Okay? Ayun, that's Article 1837. 1838 talks about the rights of injured partner where partnership contract is rescinded on ground of fraud or misrepresentation by one party. Okay? If the partnership or ito muna, question. If the partnership contract ganito. Can the partnership contract be rescinded? Okay? Pwede. Pwede bang magkaroon ng rescission? Yes, on the grounds of fraud or misrepresentation by one of the partners. Okay? Kasi kapag nagkaroon ng fraud or misrepresentation by one of the partners, ibig sabihin ang consent nyo, the other partners, let's say for example, there are 4 partners A, B, C, and D. Si B nagkaroon ng fraud on his part. And because of that fraud, si A, okay, ulitin natin si B ang may fraud. Okay? Si B yung nag-commit ng fraud. And because of the fraud or misrepresentation of B, si A na parang nawili. Gusto niyang, sige, sasali ako dyan sa partnership na yan because of your words. Because sabi ni B, ganito, ganyan. Okay? So, ibig sabihin, yung consent ni A is vitiated. Okay, I hope you still remember yung vices of consent, no? Vim-fu, okay? Violence, intimidation, mistake, fraud, tsaka undue influence. Now, pero kapag fraud, 'di ba, yung fraud, it is one of the vices of consent. Gaya nga ng sabi ko kanina, yung vim-fu, okay? Yung F doon, that's fraud. Now, if may fraud, okay, what is the effect on the partnership contract? Ibig sabihin, yung consent ni A is vitiated. Hindi naman siya mag-a-agree kung hindi ganito yung sinabi ni B, kung hindi niloko ni B si A. Okay? Dahil sa panloloko ni B, hindi, kikita yan, ganito, ganyan. Okay? Legit to. Mga ganon. Di si A na pa-agree. Pero vitiated ang kanyang consent because of the fraud committed by B. Now, what happens? Can the partnership contract be rescinded? Yes, pwede. Kasi the effect is, yung contract nagiging void or nagiging void siya. What is the remedy for void? Sorry, hindi void. Voidable. Okay? Kasi kapag vitiated ang consent, the contract is voidable. Okay? Now, what happens kapag voidable ang isang contract? Okay? Ano bang or ano ba ang status ng isang contract that is voidable? Okay? It is valid until annulled. So once it is annulled, okay, adi yun na. Mawawala yung contract. Okay? Now, or pwede rin magkaroon ng rescission. Okay? That's another remedy. Now, what happens if the contract is rescinded? What is the right of A dun sa example natin? Okay, meron siyang number 1, right to lien on surplus of partnership property after satisfying partnership liabilities. Kasi 'di ba, after satisfying partnership liabilities, there is a possibility na may matitira pa. Okay, there is a possibility na magkaroon pa siya ng surplus. Now, a lien can be attached on that partnership property. Okay? Kasi syempre, liable si B kay A. Kasi nga si B yung nag-commit ng fraud or misrepresentation. So si A, meron siyang right na mag-attach ng lien or magkaroon ng claims dun sa partnership property. Okay? To protect yung rights ng injured partner. Okay? Number 2, right to subrogation in place of creditors after payment of partnership liabilities. So, ang subrogation kasi, you are acquiring the rights of a creditor. For example, si creditor C, okay, meron siyang right na mag-receive kay D kasi si D may obligation kay C. For example, D is obliged to D is obliged to give 10,000 kay C, for example. And then, ano nga ba? Paano nga ba tong okay, si D is obliged to give 10,000 kay C, and then si A, hindi, si C may utang kay A. Okay, ayun. So, anong pwedeng gawin ni A? A can be subrogated in the place of C. Okay, ibig sabihin, instead na si C ang magre-receive ng payment from D, okay, imbes na ang babayaran ni D ay si C, ang babayaran na ni D ay si A. Kumbaga, si A na ngayon ang naging creditor. Okay? So, parang ganon. That's subrogation. Now, a partner or an injured partner can have the same right. Okay? And, of course, right of indemnification. Ibig sabihin, the guilty partner, kung sino yung nag-commit ng fraud or misrepresentation, kailangan niyang or may karapatan si injured partner na humingi ng danyos doon sa guilty partner. Okay? And Article 1739, eto na, yung settlement of accounts. Eto na yung accounting part. okay, ng ating lesson. So, how are the accounts of the partners being settled? Okay? So, Article 1839 begins with identifying which or what are the assets of the partnership. Okay? So, number one, doon sa Article 1839, sabi niya, the assets of the partnership, ito, okay, 1839. The assets of the partnership are A, the partnership property, B, the contributions of the partners necessary for the payment of all the liabilities specified in this. Okay? Kasi, kung sakaling magkulang, the partners are required, the capitalist partners are required to make additional contributions. Sa pag-usapan na natin yan. Okay? Okay, so yun na ngayon ang bumubuo doon sa assets ng partnership. Ito ngayon ang i-distribute sa mga parties na involved, no? So, itong mga assets na ito will be in satisfaction of the following credits. Okay? Ang unang-unang may priority is yung mga creditors. Okay, other than the partners. Can the partner be a creditor of the partnership? Pwede. Yun nga yung loans from partner, di ba? Okay? Yun. So, ang partners pwede rin maging creditor. So, ang sinasabi nito, those owing to creditors other than partners. Okay, yung mga creditors na hindi naman partner. Kasi ang partner pwede rin maging creditor. Hindi kasali yun dito sa letter A. Okay? Pangalawa, those owing to partners other than for capital and profits. Okay? If you remember, ulitin ko doon sa pag nagso-solve tayo ng pag-partnership liquidation, no? Isipin na lang natin lump sum for example, no? O, di ba, isusulat nyo yung cash and then non-cash assets and then loan from A. O kaya A loan, di ba? Kapag yung A loan nasa debit side, okay? Ibig sabihin that is a receivable on the part of the partnership. Ibig sabihin mababawasan yung credit ni A. Pero kapag yung A loan nandun sa credit side, that is a loan from the partner. Okay? Ibig sabihin, si partnership ang may utang kay partner. Yun. Ito yung nasa letter B. Okay? Now, letter C, those owing to partners in respect of capital, ibabalik yung contributions mo. Okay? Now, if meron pa ring sobra, ayun na, in respect of profits. Okay? So, ganun natin siya dinidistribute. Okay? Ayun lang naman ang mahalaga dito. Okay? Ayun, ito. The partner shall contribute. Kung kulang pa rin yung liabilities, okay, kulang yung assets, pambayad doon sa liabilities. 'Di ba nag-additional ano 'yan? Nag-additional contribution tayo. 'Di ba ginagawa na rin natin nung FAR natin? Ganon din. Okay, ito 'yon, number 4. An assignee for the benefit of the creditors or any person appointed by the court shall have the right to enforce the contributions specified in this preceding number. Okay? Kasi syempre, kapag hindi nag-contribute yung mga partners, edi yung mga creditors, wala silang makukuha. And so, to enforce their rights, okay, i-enforce nila yung mga partners to make additional contributions. Okay? O, ganun din. O. Ayan. And then, the individual property, yung estate ng isang deceased partner shall be liable. Okay? Kahit patay na yung partner, pwede siyang magbigay ng additional contributions through his estate. Pero syempre, hindi mismo yung patay. Okay? Ayan. Ayun. So, that's 1839. So, maybe in your quiz, maglalagay kami ng problem solving. Actually, in your, tignan nga natin sa LMS nyo. Ayan. Oh, meron nga. Ayun. Oh. To answer this question, you need to know or you need to understand yung Article 1839. Okay? Ayun na siya. Ito na. It is summarized dito. Ganyan lang. Okay? Order of application of assets. Okay? You have to remember, creditors muna, except mga partners na creditors din, hindi sila kasama dyan, dito sila sa pangalawa. Okay? And then, return of capital contribution, and then if may tira pa, yun na yung remainder na i-distribute din sa mga partners as profits. Kasi may sobra ibig sabihin may profit. Okay, so yun. Ibabalik din sa kanila yan. Although itong number 3 and number 4, isahan lang yan if you notice doon sa FAR natin, noong nagsosolve tayo ng mga ganyan, nagiging isa to. Okay? Pero sa batas hindi. Okay? Dapat mauna ito for capital contribution and then last ito. Pero sa FAR, pinag-iisa natin yan. Kasi saan ba pumupunta ang net income? Okay? Siyempre sa equity. Okay? In the case of partnership, hinahati-hati yan. Okay? And then mapupunta kay A capital, kay B capital, kay C capital. At nahahalo siya doon sa original capital contributions ng mga partners. Okay, so naghahalo sila. So, kapag may cash sa debit side and then yung balances or capital balances ni A, B at C at pantay naman, o di ganun na, di ba? Dinidistribute na natin. Hindi na natin siya pinaghihiwalay dito. Okay, pero under the law, hindi. Dapat maghiwalay siya. Okay? Okay, and then last, ito, if the business of the dissolved partnership is continued, okay, very sensitive kasi ang definition ng dissolution Pag sinabi mong nadagdagan yung partners kahit isa lang or nabawasan yung partners kahit isa lang din, okay, dissolve na ang partnership. Pero that does not mean that the business does not continue. Pwede magtuloy-tuloy pa rin yan. Now, if that happens, okay, these are the rules, no? The creditors of the old partnership are also the creditors of the new partnership. Okay, malamang. Diba? Okay, creditors have an equitable lien on the consideration paid to the retiring or deceased partner by the purchaser when the retiring or deceased partner sold his interest without final settlement with creditors. Okay, so yung binayad doon sa umalis or namatay na partner, okay, merong habol doon ang creditors. Okay, kasi baka naibigay sa kanya yung kanyang interest without final settlement with creditors. Okay? And ayan, rights of the retiring or estate of the deceased partner. Okay, 'di ba? Doon sa partnership dissolution na lesson natin noong sa FAR, what if may withdrawal of a partner or retirement or death of a partner? Kino-compute natin yung net income, 'di ba, until that point. And then tinitingnan din natin yung capital balance niya, tapos tinitingnan natin kung may asset revaluation, ganyan. So basta nagkakaroon kasi ng computation at the time of the death of the partner or at the time of the withdrawal or the retirement of the partner. Bakit? Kasi karapatan niya yon. Okay? Karapatan nung withdrawing or retiring or deceased partner, okay, na makompute kung magkano ba ang kanyang interest as of the date of the dissolution. Pag na-compute na yan, ibibigay sa kanya yan, di ba? Ayan, no? To have the value computed or ascertained at the date of dissolution and of course to receive the same. Okay? O, yun. And then, ito na, yung 1836 kanina pinag-usapan natin. So, that, guys, is lesson 3, dissolution and winding up. So, I see meron ng mga nakapag-submit ng assessments natin. Syempre, touch move yan. Pero for those who have not yet submitted, pwede pa naman humabol. Okay? Deadline is on Saturday. Thank you guys and have a wonderful day. Thank you so much.